The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the January 21st, 2021 sitting of the Massachusetts Appeals Court. My name is Eric Neyman. I'm sitting today with Justice Kenneth Desmond and Justice Vicki Henry. We will be your panel today. One case we have on is docket number 2019 P0071, Commonwealth versus REDDICKS. As discussed, each side will have 15 minutes to present argument. There is no rebuttal. We will hear first from counsel for the appellant, Attorney Scapiccio.
Good morning, Your Honors. May it please the court. My name is Rosemary Scapiccio, and I represent Charles REDDICKS in this appeal. The first issue that I'd like to discuss with the court is the practice that Suffolk County has of running jurors' records. And our argument is that it violates equal protection because that specific policy of running jurors' records reinforces systematic racism within the system. And the reason that I say that is because of the jury questionnaire, the issue of criminal record is the only one that we disbelieve the jurors about. In other words, when we look at their interaction with the criminal justice system, we don't disbelieve them when they say, have they ever been involved in a civil case? We don't disbelieve them when they say they've never been the victim of a crime. We don't disbelieve them when they say they've never worked for law enforcement, but we focus in on this one issue of criminal records. And it is clear now in today's society that criminal records checks adversely affect people of color. And by
Attorney Scapiccio, so first, in your brief, you even recognize, I think, that Cousins permits the Commonwealth to run the record.
I do recognize that, Judge, but Cousins doesn't address the racial issue that I'm addressing here.
All right, so I'm going to get to that in 1 second, but let me ask you this. Also, when you objected to this at the hearing, didn't you also ask alternatively that if they were going to run records, that they also run prospective jurors to determine whether or not they had been victims or witnesses in other matters?
I did object, and I did make that request. So in my motion in limine on this matter, which I think appears in the record appendix on page 131 and 130 to 133, I made an objection to them running the records at all. I don't want the records run. I think it's implicitly biased to run the records. But if the court is going to run the records, let's level the playing field and force them to run them through the victim witness database and through other databases to make it a level playing field, because it doesn't benefit the defendant to run a criminal record. The person, the entity that would benefit would be the Commonwealth in this case. And what happens is exactly what happened in Mr. REDDICKS' case, which is two Black jurors were cleared. Then they had these minor incidences on their record, and the Commonwealth used that as an excuse to dismiss them.
Sure. And so, did they run the records for witnesses and victims? Did that occur? Do you know?
I believe the representation of the Commonwealth was that their victim witness database was not up to date, that they didn't know how accurate it was, but that they would run the names through whatever they had, because their database is not complete. That was what was represented to us at trial.
And isn't it beneficial to both parties when the jurors make truthful answers in the questions that are put to them before sitting as jurors?
Absolutely. And
it doesn't just favor the government, it favors the defendant as well. Aren't they interested
I don't
in
believe
whether or not they're false answers?
I'm sorry, I didn't mean to interrupt you, but I don't believe so, because if you take a step back from what the results of running the records are, and we look at why we're running the records. We're running the records because we disbelieve people about their answers under oath to whether or not they've ever been involved in the criminal justice system. And that has to presuppose, A, that you've been involved in the criminal justice system, and B, that you're gonna lie about it. Because you've already signed the waiver under the questionnaire under the pains and penalties of perjury. And that's
what's your best case for that? For your argument that you just made, do you have a case that supports that?
That says there's implicit bias? I think the cases that are coming out of the SJC and the appeals court now talk about implicit bias.
No, that says the reason we're running the records is because we don't believe the jurors. And what case are you relying on?
No, that's just implicit in what they're saying, Judge. So there's no case that says we don't believe the jurors. They're never going to say that. That's the Commonwealth.
That's certainly not what Cousins says, right?
Well, Cousins doesn't talk about the racial disparity.
But
Cousins
it talks about running queries with jurors. That's what we're talking about.
But I understand that. And so the issue in Cousins was different. The issue in Cousins isn't the results. So now we've been running the records for 12 years. And now we know.
The issue, I think, is the practice of running queries for potential jurors. Is that the issue?
That's the issue. No, it's not the whole issue, Judge. It's the racial disparity that results from running the records of jurors. So that's what we're dealing with here today. We're not dealing with whether they can or they can't. We're saying now that we understand that we're running these records, and we understand now that it is implicitly biased and racist to run these records, because the effect of running the records is a policy that reinforces systematic racism, because it disproportionately affects Black and brown jurors, disproportionately affects Black and brown jurors. And it's time that stops. And just so the court is clear, it's not every county that runs criminal records. It's Suffolk County. We're talking about Suffolk County today because it's Suffolk County's policy of running these criminal records. And what I am saying is, why are we automatically believing this section of the disbelieving this section of the population that we know is predominantly Black and brown because of the criminal records check? Why don't we disbelieve them on other things that they've represented? Why do we have this implicit bias and now this policy that allows the implicit bias and racism to exist in the Cousins decision? That's why.
I'm sorry to interrupt you. Judge Henry, please go ahead.
No, you go.
I'm sorry.
No, it's okay. I don't see in your brief that you set forth the constitutional test for this particular equal protection challenge. And I think, as I understand it, the Commonwealth sets it forth at page 26 of their brief. They set forth a 3-part test. Do you agree that the Commonwealth has properly set forth the test?
For a challenge to the Constitution?
For the equal protection challenge that you're making in this case.
But I think the Commonwealth is recasting what we are doing here. What we're suggesting is the running of the Corey records here, it violates equal protection and the defendant's right to a Sixth Amendment jury of his peers, because.
So let me stop you right there. So there is an equal protection challenge. The Commonwealth sets forth in their brief at page 26 a 3-part test for the court to evaluate an equal protection challenge. And what I'm asking you is that the correct test here?
I have no doubt that it's the correct test as far as challenging equal protection. What I'm saying is they've recast the argument to make it something that it's not. That's what we said in our reply brief. If you look at our reply brief, it will tell you what our real argument was, not the argument that the Commonwealth wants this court to address. And we're trying to address.
So to get back to my question, though, since there is an equal protection challenge, that I understand you're saying that they're misstating your argument. But if they have the correct standard for an equal protection challenge, the second prong requires a demonstration on your part that the group is not fairly and reasonably represented in the venare in relation to its proportion of the community. And the third prong is that underrepresentation is due to a systematic exclusion of the group in the jury selection process. My question for you is, how do you meet that second prong that I just stated here?
I think the record is clear in this case that we made the objection. If you read my motion to eliminate, it lays out our whole objection, indicating the systematic racism that existed in the disproportionate effect on the Black and brown community. What I said to the judge at sidebar is that this is disproportionately affecting Black and brown people. This is why it's wrong to run these records, because you're giving the Commonwealth another opportunity to say no to a juror of color, when in fact there wasn't any reason to say no before you ran the records. That's the system that we have in place that allows for this implicit bias.
So in the test, though, do we look at your particular jury, or do we look at the venire generally? Because here we have the judge saying there were 5 African Americans. At that point, I don't know out of how many. And how do we know whether that makes the group not fairly and reasonably represented?
I think even one strike of a juror who had the right to serve, who Mr. REDDICKS had the right to be on his jury, makes it a problem in this case. And the Commonwealth is essentially saying that it's not true. Now, Henderson, which I think is what you're talking about, Justice Henry, I think Henderson is different because in this case, what the trial judge did is she said, I just want to wrap up what trial counsel said. And so just for the record, there are 5 Black jurors. That's not enough. What the trial judge should have done is looked at the entire veneer and made that calculation that she was supposed to make, that Henderson said she was required to make, that she didn't make in Ortega and she didn't make here. Same exact trial judge, same exact result.
How many African-Americans ended up on the petite jury?
According to Judge Giles, five.
I'm asking you, you were the trial counsel, right? I'm asking you.
Yes. 5 people. I'm sticking to the record, Judge, and so what the record shows is 5 people of color. I can't say I recall whether they were African-American, whether they were Asian, whether they were Hispanic. I do not recall. The record shows from Judge Giles that there were 5 minorities on the jury. And that's the problem. That's why it's different from Henderson, because in Henderson, what the SJC said is that if all they do is look at the makeup of the jury and say we're good, it's not allowed. And that's exactly what the judge did in this case. And so I'm suggesting this case is much more in line with Ortega, where the same judge did the same thing, saying we have enough minorities, so the fact that the Commonwealth may have struck a juror that under SOARS or under any other relative issue is okay because the final outcome is 5 minorities. And that's not what Henderson says.
That's a legitimate factor of the analysis, although it's not dispositive. But getting back to Judge Neyman's question, on what evidence do you rely? I mean, I understand your argument, and anecdotally it sounds fine, but what evidence did you put in support of the composition of the veneering?
I think the evidence is not only that these 2 people were excused and one excusal of a juror based on race is enough, but the fact that we filed a motion in limine, and at sidebar, we explained to the judge what's happening. We didn't just raise it on equal protection grounds. We raised it on due process grounds as well. And so due process wise, how do you get around it? How do you get around the fact that this is happening and it's in the policy allows for systematic racism? You know, if you evaluate it under equal protection or under due process, my suggestion is the policy is racist and it should stop today.
Now, you refer to it as a policy. Didn't the government file a motion in limine to be allowed to do it?
Right. It's the policy in Suffolk County. They file a motion in limine in every single case. Every single murder case that I've been involved in for the 30 years I've been doing this, since the Cousins case came down, they file motions to run jurors' records, and I file oppositions to them every single time. And what happens is exactly what I said to the judge was going to happen in this case. They're going to find jurors of color who have been already vetted and said that they were not biased, that they could sit on the jury, and then somebody has a motor vehicle violation from 11 years ago, and you're going to use that as an excuse to get them off the jury? It's a backdoor way to be, to strike black and brown jurors, and it's a policy now. It's a policy of Suffolk County that should change.
In this case, one of the jurors, it wasn't a motor vehicle incident. I believe he had a domestic violence matter. I believe he had an assault and battery on a public employee. It appeared that he had a number of matters over a number of different years that he believed were all sealed. Would you say that that's different?
I do.
Than a minor motor vehicle accident?
I don't think it's different because it's the same response. He said he was confused. He thought it didn't count because it was sealed. And the judge found that all of his answers and the other jurors' answers were not intended to defraud the court, were honest and reasonable, given that the question itself could be used in a couple of different ways. And if I could I have 3 other arguments that I want to get to very quickly, if I could just move on. The issue of restricted cross, in this case, it was the firearm issue. This is where Thomas Washington testified that the defendant possessed a gun, and the Commonwealth focuses on whether or not you can talk about it as a prior bad act. I'm focusing on the restricted cross. I was restricted from cross-examining Mr. Washington at all about what happened with that gun. I had information that's contained in my motion in limine at pages 130, record appendix 137 and 138. And in that record appendix, I said to the judge, there was evidence from the actual victim in that case where they were claiming my client had a gun. His name was Johnson. And he said it wasn't REDDICKS who had a gun, it was Ghost who had a gun. And then in the closing argument, the prosecutor argued, we know it was REDDICKS who tucked his gun in just like he had done before. And then
I'm sorry, go ahead, let me let you finish.
And then in terms of the improper ID, the Commonwealth claims that there was no improper ID in this case. What happened was Detective Daly identified my client when he said that he looked at the car and he noticed that it was REDDICKS' grandmother's car. And then he looked at the photo from the Registry of Motor Vehicles and he said it matched the description that Leanne Parker gave. Nobody else that
Did he say, I'm sorry to interrupt, did he say matched, or did
He
he say, I thought he used the phrase, did any of the other licensees, if you will, fit the description?
No, you're talking about two different things, Judge. One was who was in the house so that he could focus on whoever he wanted to. And then when he pulled the registry records, he said the photo of Mr. Reddicks at the registry matched Leanne Parker's description. The problem with that, as I understand it and as I see it, is there were 3 people in that car that Leanne Parker saw. How does Detective Daly know that the person who came out was Reddicks? He can't. And yet he told the jury it was true. And in the closing argument, the Commonwealth argued that effect. And then finally, with respect to the voluntariness of Mr. Reddick's statement, he was a few days past his 18th birthday. He made a statement that the trial judge found that there was the now or never language, but that Mr. Reddicks wasn't affected because his will was not overborne and he didn't change his testimony. In the Miranda case, the same thing happened. It doesn't matter if you change your testimony or not. The prejudice comes in the closing argument. And I'd ask you to look at pages 48 through 56 in the closing argument, where the Commonwealth said my client lied about being a marijuana dealer, lied about being in contact with Ian, and lied about dealing drugs. That's where the prejudice comes in, and that's why the case should be reversed. And I'd ask, I know I'm out of time, I'll take any questions that the panel has on any of those issues. I know I got a little caught up on the first issue, but it's an important issue because I think it's time that policy end.
So I do have just a couple of questions. The Commonwealth, on the revolver that's in the pictures that were admitted, the Commonwealth argues that firearm could have been the firearm used for this murder. What do you say to that?
It could have been one of a million firearms. It was a revolver. That's all they knew about it.
So,
they didn't know any more than that.
But I was left from the briefing entirely unclear about the order that these things happened. So when was he charged with that firearm? When did he plead? How was that in relation to just have a quick chronology?
He was charged with the firearm prior to this offense. The date of offense of the firearm was about 4 months prior to the homicide in this case.
But the firearm wasn't recovered?
The firearm in the homicide, the firearm in the prior case was. He was charged with that firearm.
But it was recovered after this homicide? That's what I don't understand, how it could be the same gun.
No, it can't be the same gun. That's the bottom line. It can't be the same gun. It can't have been the same gun.
Okay.
Photographs were offered to show that the defendant had access to guns. Wasn't that the government's theory?
The government's theory was, yes, it was offered to show that he had access to firearms. But here's the problem with it.
Particularly revolvers, right?
That's what the Commonwealth theory was. Absolutely, Justice Desmond. Right. That's what the Commonwealth theory was. The problem with that isn't just that it was offered for that purpose. It was the complete restriction on cross-examination, which the Commonwealth doesn't address at all.
Well, I didn't see a complete restriction in looking up the transcript. I saw Judge Giles say, I can't really anticipate what you're going to say, so I can't tell you no, but I'm telling you to tread lightly because you may very well open the door for the prior conviction to come in. That's what I read from the transcript.
No, Judge, I respectfully, I will supplement what I have with a 16L letter, because what Judge Giles said to me was that, no, I couldn't go into it. If I did it, she was going to let the jury, she was going to have the Commonwealth not only introduce the fact that my client was convicted of a firearm, she was also, and he was charged with a firearm in this offense, which would have been prejudicial, but she was also going to let the jury know that he shot at someone, which A, wasn't something that he pled guilty to, and B, is way beyond a prior conviction. So I had no choice. I was completely handcuffed in my ability
I take it you're saying that we should be looking at the trial transcript in conjunction with your motion in limine on this issue, which might be more robust than what we're seeing in the transcript?
Yes, so the motion in limine is exactly where I lay out all of the facts of why I say that I should be able to cross-examine on this issue, because there was a dispute as to who had the gun. And there was evidence that Mr. Reddicks didn't have the gun under those circumstances. And she said that it would perpetrate a fraud upon the court to cross-examine on that issue because he had pled guilty.
Okay. I just had one other question, which is you talk about the search warrant in the other case where the police then retrieved the photographs of the defendant holding a revolver. What's the record support that the defendant raised a general challenge to the search of the phone that included the breadth of the search warrant? The Commonwealth seems to think it's not preserved.
It is preserved, and it's preserved both at trial and in the motion in limine on the firearm. And you can find the motion in limine on the firearm at Record Appendix page 137, I think is where it starts. And it lists all of the reasons why the firearm shouldn't be included, including the restricted cross claim, including the photos claim. And there's also a motion in limine regarding the photos of the gun. And we had a lengthy hearing regarding the photos of the gun. There were several guns. The Commonwealth had indicated that it wanted to introduce more than one gun. And we had lost on that motion in limine, and ultimately those photos came in.
Okay.
Any further questions for Attorney Scapiccio from the panel? Seeing none, thank you for your excellent argument. We will now hear from the Commonwealth.
Good morning. May it please the court, Julian Campbell on behalf of the Commonwealth. I'm here today asking that this court affirm the defendant's convictions for second-degree murder and various firearm offenses for the shooting death of 25-year-old Mr. Mariano Malev. If I could first clarify the factual question you asked Justice Henry regarding the sequence of events. So I believe it was in December 2011, the defendant was ultimately convicted for, I believe it was possession of a firearm that stemmed from a shooting that had occurred in December 2011. Accompanying the defendant's arrest, the officers in that case had seized and executed a search warrant on the defendant's phone. Approximately 4 months after this, the defendant is the murder of Mr. Malev in April of 2012, the first arrest, I believe, occurring around December of 2011. During the pendency of the homicide trial, the defendant litigated, or not the trial, but the pendency of the homicide case, the defendant litigated the firearm charge from December 2011. He did litigate a motion to suppress. The order denying that motion to suppress is in the Commonwealth's appendix at page 24.
Okay, so
And-
in December of 2011 is when he was charged with possession of the firearm, but then you're saying it was litigated after the homicide charge.
No. So there was a firearm offense that the defendant was charged with and pled guilty to. In that offense, there was a search warrant executed. With respect to that docket number, which the Commonwealth has included that docket in its appendix at page 3. With respect to that case was going on. A motion to suppress was litigated. The defendant lost. The homicide occurred in April 2012. The defendant was not indicted until after that date. As that was going on, it was on as styled as a motion in limine that Ms. Scapiccio filed to exclude or to read the contents of the search from the firearm offense.
Right, so what I based on Commonwealth versus Snow and many other cases, I don't understand how the search warrant for the phone issued in the firearm case, because there's no indication of firearm that a phone was used in connection with that offense. And it doesn't seem like it would survive the many cases that say there needs to be a connection to the crime.
So, Your Honor, respectfully, I did not, what I can tell the court is based on I apologize. There was a search warrant for that offense. A motion to suppress was litigated. The defendant lost it, and that decision outlining Your Honor's concerns is in the Commonwealth's appendix, in which case the judge found the connection to the search of the phone. The warrant was supported by probable cause. That was litigated. There was mutuality of the parties, and it's the Commonwealth's position. I understand the issuance of Snow. However, what I would suggest is that even with respect to that, even in Snow, because the record wasn't fully borne out, that case had to be remanded for further determination consistent with the SJC's opinion. But here, we don't have that record because Ms. Scapiccio certainly filed a motion in limine arguing many of the things that were in Snow. However, the constitutionality of that search and of the breadth of the warrant had already been decided in a prior case. And so it's the Commonwealth's position that they were stopped from relitigating it when they had an avenue of appeal and did not so seek an appeal or reversal of the suppression order.
So let's go back to the jury selection. why is the Commonwealth running the criminal records of prospective jurors?
Sure. So I do want to just, I object to counsel labeling this as a Suffolk County only practice. I certainly know that she is well-versed in the many courts of this Commonwealth. However, there's nothing in the record to support that this is a practice exclusively in Suffolk County to run query checks. In fact, it is permitted by Commonwealth v. Cousins. I would suggest that here, I know the defendant, that here, any use of the peremptory challenges by the Commonwealth was completely proper. I know the defendant in a brief seems to suggest initially, at least, that it was a source objection. I think the record is quite explicit in that it was not, and that
Counsel, why is the,
sure,
why are you running the, I just want to know that seems relevant, and
sure,
it's an issue the defendant has joined.
So in many of the cases cited since Cousins that rely on Cousins, they speak to the concerns that the Commonwealth may have, as may any party may have. But with respect to running the jurors' query checks, I would suggest a number of things. One, if someone does have a prior interaction with police in any capacity, it could certainly lead someone to have a bias either for or against police, whether they were a victim, whether they were a witness, or whether they were a defendant. Additionally, I would suggest that running the query checks reveals things beyond the simple existence of a query record. For example, it could reveal how attentive a potential juror is to filling out the questionnaire before them. If all of a sudden on a query check, it reveals there's a 5-page query and nothing had been disclosed on the record, it could suggest that there is an attempt to not be candid with the court. There are many, many reasons that the Commonwealth in general may be seeking to run query checks, all of which are permitted by Commonwealth v. Cousins. And I certainly understand my sister's argument that this leads to a racial disparity. However, as Justice Neyman pointed out, there's no engagement in the legal analysis here that's actually required on behalf of the defendant. And I'd suggest that with respect to this claim, it is their burden, and they simply cannot show it based on a single veneer that's before.
So, counsel, has there been a history of racial discrimination by law enforcement against Black people?
I certainly can't deny that.
Okay, so once we think that that is a true thing, and there certainly seem to be a number of references to it, as counsel mentioned, from the Supreme Judicial Court, including in Commonwealth versus Warren and Commonwealth versus Long. I mean, in Long, which just issued, they said years of data have borne out what many have long known from experience. So once we know that that's happening and there's a disparity, what should we be doing about it? I mean, you don't seem to be arguing the basic proposition, which is that there is a disparity in stops and a disparity in charges, and this covers not just convictions but charges. And we also know from the Harvard study that was released that there's a disparity in the severity of the crimes charged.
So, but Your Honor, I think what you're speaking to are sort of larger concerns. What is in practice now is that the Commonwealth is not permitted, or any party in any case, is not permitted to strike a juror for race or gender. Any other reason, a Commonwealth may use a peremptory challenge.
This just becomes a proxy that sounds like it's facially neutral, but in fact is not facially neutral.
But Justice Henry, it is facially neutral in that if you think about the context of what's actually happening, there are jurors of color who are seated with the consent of the Commonwealth. The Commonwealth has no way of knowing whether they have been untruthful or not in its questionnaire until it runs the query checks. So to presuppose that the query checks—
This one factor, I guess one of the concerns I had as I read the transcript was that the trial judge said repeatedly that many jurors misunderstand this question, and that she found that they're not answering, like take, for example, the guy whose record was sealed, unless the questionnaire says you have to list all sealed charges. I think a lot of people would not list. I think based on simple information campaigns, most people probably would not list a sealed charge.
Your Honor, but that still could be a basis by which the Commonwealth could be concerned about a potential bias against the Commonwealth. Now, I understand that these are not jurors excused for
Would that
cause
be a bias against the Commonwealth?
due to previous involvement with law enforcement. That's the whole reason Cousins permits parties to run the BOPs of jurors. So I understand the court's concern, but I have to return to the fact that this defendant on this record has simply not made the showing that he needs to make in order to support his claim. And I would ask that this court deny relief, at least on that ground.
So the defense counsel mentions as support for her claim that the prosecutor did not ask any white jurors about childcare limitations. Is that true?
I don't know how that is supported by how that claim specifically is supported by the record when the record does not state the race and jurors of the race of all prospective jurors or what was questioned. I was not at trial. I frankly don't know how that can possibly be supported by the record, and I do object to the characterization.
I have a question about
Certainly.
On the firearms, you say that Valentin and Barboza are distinguishable because in those cases, the defendants possessed firearms that were definitively not the firearm used in the crimes.
Yes.
That begs the question. On the record before us, is it clear that the firearms so I think that's in the photographs, and the one that Washington referred to in his testimony, is it clear from context that that could have been the firearm used in this case or no?
So it was argued, I want to be very clear, the judge instructed at least twice, I believe, with respect to this goes to the defendant's access to firearms. So there's a couple of things. I don't think it's definitively proven that the photographs are the same gun that Thomas Washington necessarily saw. They certainly could have been the same gun. I don't think there's anything to suggest that they exclusively were the same gun. And similarly, I don't think there was anything to exclusively say that those were the firearm used in either one was the firearm used in the homicide. But again, that the defendant had access to revolvers just 4 months prior to the murder in this case.
Right, but you're saying that Valentin draws a line, and that line is that gun could never have been used in the homicide at issue in that case.
Correct.
And therefore, the prior testimony was irrelevant and prejudicial, and potentially prejudicial. It should never have been introduced. You're saying that is not the case here because it could have been used. It is not ruled up. Is that correct?
Correct. So for example, if the photographs and Thomas Washington referred to a semi-automatic weapon, I think this would be a very different posture and argument before this court. But here, because it was a revolver, it was important that the jury at least see that prior to the homicide, he had access to revolvers.
Well, so that begs this question, which is, I understand that the judge has ample discretion in deciding whether or not to admit that kind of evidence, that kind of information into evidence. But what type of temporal nexus should we be looking at? In other words,
So
there's some cases where the gun was possessed, the prior gun was possessed 3 days before the homicide. That's clearly relevant to show access to a firearm. But as we move farther along, it becomes more and more tenuous.
I can tell the court I'd be happy to submit a 16L letter with a case regarding the outer limit. I know that I can't provide a case to the court right now, but I know that there are cases longer than 4 months. And what I would suggest about the temporal limit is especially why both Mr. Washington's testimony and the photographs were necessary in conjunction with each other to establish the temporal limit. Specifically, so Mr. Washington testified that it was in December of 2011 that he had seen the defendant holding a firearm. That was ultimately the firearm that the defendant pled guilty to having. And
so we know that gun wasn't the murder weapon.
Your Honor, I apologize. I actually don't know if that gun was ultimately recovered or not. I just don't know.
That wasn't recovered?
I'm sorry?
He pled to a gun that wasn't recovered?
I don't know if he did or I apologize to court. I don't know whether he did or did not, but I know that other witnesses described him participating in the shooting.
Right, but that's what I'm confused about and what I was asking at the very beginning of the argument. If the gun was recovered in that case, it seems like it could not have been the murder weapon.
If it was recovered, perhaps, Your Honor, but there were also, and this is what I'm trying to come back to, why the two pieces were necessary for each other. There are photographs on the defendant's phone of what gun we do not know. We do not know if it was a recovered or unrecovered gun that was used in that shooting incident. However, the photographs were recovered from the defendant's phone in December 2011. I believe they're photographs of a silver revolver, which is in fact what Mr. Thomas Washington described. But either way, I would suggest it's a very general description, and that the photographs were necessary to demonstrate that the defendant had access to firearms. Mr. Washington's testimony was necessary to demonstrate that he had access to firearms 4 months prior to the homicide. And if I could just briefly, I see that I'm out of time, but while I am on Mr. Washington, I just want to read to the court specifically, and this is from January 12th, the motions in limine practice, but counsel continues to assert that she was denied the opportunity to cross-examine Mr. Washington. And in reality, on page 77, and this is after a lengthy conversation with the court, about Mr. Washington. The court stated, if you start attacking Mr. Washington's credibility and arguing to the court, don't believe him, he's a liar, you know my client never possessed that gun, that's a false narrative because we all know your client admitted to it. I'm just warning you, Ms. Capiccio, I don't want to make any prejudgments here. The farther you go down that road, I think that conviction could come in. If you argue not to believe Mr. Washington, it strikes me as unfair to the Commonwealth not to introduce the conviction if that's the tact you're going to take. It's uncontroverted your client pled guilty to doing that. If you take the tact that the witness is a liar, don't believe him, your client's conviction, you could be opening the door to the admission of your client's conviction. That was the ruling. It was not an all-out ban on cross-examination of Mr. Washington, but simply a warning that.
And I didn't write down her exact words, but she seemed to be saying that she had told the court what her line of cross-examination was, and that it was possible that somebody else had the gun, but her client, for whatever reason, pled. He certainly doesn't seem to have been held, because if he had been held in December 2011, I don't know how he would have committed a murder in April 2020.
Your Honor, he served time while the homicide prosecution was pending, so he did serve time.
When was his plea for the gun?
If I can just have a moment, I'm happy to look at the Commonwealth's appendix, Your Honor. It appears to be October 10th, 2013, and that's at the Commonwealth's appendix, page 7.
And
Which
can we
is
just check with,
about I apologize.
no, I just want to see if there are any further questions from the panel.
I guess the one other question I had is, did the prosecutor suggest that the defendant possessed more than one firearm in the past and that jurors should be scared by this?
I apologize to the court. I don't have the I don't have the closing in front of me, and I'm trying to recall from memory. I don't remember the explicit assertion. What I would suggest to the court is that the prosecutor gave a very lengthy closing statement. The jury was very appropriately warned what the purpose of closing statements were, that they were the party's interpretation of the evidence, that they not be persuaded by sympathies, passion, or anything like that. So I apologize to the court. I can't answer that directly about what the prosecutor explicitly stated in that line, but I would suggest that if a suggestion that the jury should be fearful would certainly be inappropriate, but I think the judge here certainly offered appropriate guidance as to the purpose of closing arguments, and I'd suggest that that was not error in the context of the entire closing.
I did actually have one other question, and I don't have the brief queued up. On the interrogation of the defendant, there is a point in your brief where you do seem to, well, you go along with the judge's finding that at some point the wrong language was used, but you don't ever actually say what you think the wrong language was.
I apologize. I believe it was the language that this is your one opportunity to tell us what actually happened. I know that's not the precise language, but I believe that was the sentiment that had been expressed. And I would suggest that that was improper. I'm not suggesting it was not. However, what the case law talks about is whether the defendant's will was so overborne with respect to that comment. And I would turn the court's attention to Commonwealth v. Durand, 457 Mass 574. It's a 2010 case. And I quote, here, the incriminating statements by the defendant were not tied to or otherwise made in response.
We're familiar with Durand. Thank you.
And I would just rely on that quote.
Any further questions, Justice Henry? Justice Desmond?
My final question would be, when the photographs came in, were there any limiting instructions contemporaneous with the evidence coming in?
Yes, if I could just have, I believe there were, if I could just have.
I can find them. If the answer is yes, I can find it.
I believe the answer is yes, Your Honor.
Thank you.
And I will submit the transcript to the appeals court today for January 12th.
Thank you. Thank you for the helpful briefing. And just for the record, both parties received excellent representation in this appeal. So thank you both very much.
Thank you, Your Honor.
I just hope that everybody's in good health. I think this case got put over because it was a health issue. So